Today's session, I think it's important because it's a very, very important day for all of us. And what it means for us, I think we all are aware of it. I think without any further ado, I will just request Sir to do the address. Sir, over to you, sir. Balram, sir.
Yes. Good morning, everyone. My greetings on Constitution Day from Chandigarh Judicial Academy. It was 71 years back that the Constitution was adopted on 26th of November 1949. This journey of 71 years has been most meaningful in the constitutional history of India. The year 2020 has been the most challenging year. The pandemic, not only in India, around the globe. 208 different countries involved in this particular human challenge that we are facing today. And therefore, the three different organs had to play a specific role, a special role within the limitations and parameters of the Indian Constitution. We were faced with threefold emergency in the country. Environmental emergency and the financial emergency. This challenge of the year 2020, a gigantic one. And therefore, each organ of the state, the parliament, the executive, and the judiciary, was required to play a special role in this particular context. The first thing that I will focus on, that this particular challenge, the central government in a country had to meet the challenge. Federalism, each state has to play its own role as such. But because of the death that came up, the challenge was that the central government had to play the role of a big brother, a cooperative federalism, may it be in the domain of public health. The central contribution was required. Similarly, in the environmental aspect, it had to be from the central aspect to ensure different aspects which could regulate and carry forward the entire process in a far more effective manner. And then the financial emergency. I'm not going into the different challenges in the domain of financial aspect, but the contribution, the role of the central government vis-a-vis the different states had to be far more cooperative. The Constitution of India is flexible. It is workable according to a particular situation as such. And therefore, this flexibility had to be regulated by the center, by the states in cooperation. And therefore, this particular challenge, the first thing which was required to be met with was to strengthen the constitution as such. Let me take just one small example. The crackers on the Diwali festival or any other festival as such. On the one hand, health, the lives of people were involved, and therefore this particular aspect, which was an environmental challenge, had to be taken care. Of course, it is to ensure that how best we can ensure during the pandemic time, particularly during the environmental challenges that we are facing in this particular backdrop. And the judiciary came forward to ban firing of crackers as such. The reason being, the judiciary felt that the lives are more important than anything else as such. And this did help in the environmental control, which otherwise, if this ban had not been imposed, the challenge would have been different in that context. It would have been much happier situation if the executive itself could have taken this particular measure, but then timely the judiciary had to step in, because the ultimate object of the Constitution is how best we can ensure public health, how best we can ensure the lives of the people in challenging times. And that's how the role of the judiciary became important in this particular context. Let me, first of all, delve upon the very basic recipe of the Constitution. The fundamental rights, the directive principles, the fundamental duties. This co-parcenary is such an important component of the Constitution. And this co-parcenary involves the three organs of the state, the citizenry of the country. One role. So that within the barometer of the Constitution, the parameters of the Constitution, that the state could function effectively. The rights of the people are important. And the government has to act within the discipline of the fundamental rights ensured under the Constitution. Rights are individual oriented. The state has to look after the welfare of the people. The directive principles are fundamental in the governance of the country. And therefore, in that particular state had to play a very effective role as to how the directive principles, which are the principles for good governance of the state, how to mingle the directive principles with the fundamental rights so that the good governance could be ensured. Gradually, this could be ensured in that particular context. And initially it was felt even the judiciary played a role, that fundamental rights are fundamental. The directive principles are subservient to the right. But gradually felt that those directive principles had to be harmonized within the Constitution. This harmonization within the Constitution, within the fundamental rights, was so very significant. And this harmony of the principles with the rights could usher in a much effective, more effective system of governance in the country. Particularly, fundamental duties had not been incorporated in the Constitution to begin with, and therefore in that context, it was felt that in this particular background, particularly after the internal emergency in the year 1975, through the medium of 42nd Amendment of the Constitution, fundamental duties were incorporated in the Constitution. Incorporation was a challenge of the internal emergency. Even now there is emergency of three different kinds as such. And therefore the role of the fundamental duties came into focus far more during the pandemic times now. Yes, the fundamental duties as such are not enforceable. But the courts have relied upon the duties of the citizens of the country. The challenge could not be met unless the citizens are aware and work within the parameters of the duties incorporated in the Constitution. The biggest challenge during the pandemic time was relating to dignity of individuals as such. Deaths were taking place. Cremation was not becoming possible because of such a situation. The mortuaries in the hospitals were full of dead bodies. What a challenge. And therefore, every aspect, every component of the state had to come forward as to how best that they could ensure. Moreover, the feeling of fraternity as required under the fundamental duties had to play a far more effective role. Not only that, renounce practices derogatory to the dignity of women. And during the lockdown time, these all months have been challenging from that particular aspect. The cases of domestic violence increased. And therefore, in that particular context, the citizens had to be aware of their advocating for good some time now. That in spite of the fact that they are not justiciable, not enforceable as such, yet they are fundamental in the governance of the country. and their constitutional duties of citizens of the country to be part of the Constitution is so significant. And therefore, when we talk of rights, we equally have to talk about the duties. Even jurisprudentially, rights and duties go together. You cannot think of rights in the absence of your duties. If no duties of the citizens, how do you expect that your rights must be enforced? It's the blending of the two which is important, which must be carried forward effectively. And therefore, I would urge that the state co-partnery must ensure that the duties should operate as limitations on fundamental rights of the people. Not absolute. The duties are limitations on the rights of the people. To realize the judiciary need to enforce that these duties are going hand in hand with the rights of the people. Unless and until this mixing of the two is ensured, there would be difficulties in that context. I must realize as a citizen as to what is my in that particular context. I need to take into consideration if I am claiming a fundamental right, I must not impinge upon the duty which is cast upon me. The duties are to be respected as much as you wish the rights to be ensured. And this mixing of the two together is so very important, significant in that context. The recipe, therefore, in that particular context, has to be kept in mind. And let me here refer to the basic structure which came into focus in the year 1973 through the medium of Keshwananda Bharati case. Now, basic structure, as such, the expression has not been used in the Constitution. This silence, the voice was provided by the Supreme Court. And it has proved over the years that basic structure of the savior of the Constitution. Yes, the Parliament has to do the repairing work of the Constitution from time to time. The Constitution of 1950 or the Constitution adopted in 1949 is not the same the Constitution of the year 2020. 104 have been performed by the Indian Parliament during this particular time. That's that. But what had to be ensured that the basics of the Constitution must not be tinkered with. That's a very important aspect. repair the Constitution, amend the Constitution, keeping in view the change of time, but don't tinker the basics of the Constitution. And that's to be during the last 47 years as such as the savior of the Constitution. Now, in this particular part, Article 32, Article 136, Article 142, Article 2 to 6, they constitute part of the basic structure of the Constitution. Article 32 is significant. To the fundamental rights, you can directly come to the Supreme Court. Recently, there has been some tension regarding the availability, the enforceability of the rights through the medium of Article 32. And therefore, the question that arises is that should always, for the enforcement of fundamental rights, approach the Supreme Court under Article 32? Or should they not be going to the High Courts under Article 2 to 6 of the Constitution? It has been throughout that yes, go to the High Court, and if you're not satisfied, on appeal come to the Supreme Court rather than invoking the original jurisdiction of the Supreme Court under Article 32 of the Constitution. Now, here in this particular context, what happens is it is beneficial to go to the High Court first, in the sense, if you're not satisfied, you have the remedy on appeal, say under special leave to appeal 136 of the Constitution. But if you directly go to the Supreme Court, then one remedy, and if a mistake is committed, an error is committed by the Supreme Court, you are left with no other option as such in that context. And therefore, these articles are to be interplayed in such a manner that the best out of it could emerge. For instance, the public interest litigation was something which helped connecting the people with the Constitution. That was the basic requirement. When the Constitution was adopted, the preamble begins by saying, "We the people of India." And it is we the people of India who get connected through the medium of the public interest litigation process as such. When any development takes place, the use of it and the abuse of it, they go together in that particular context. And therefore, in this particular background, I would say when the rights of a group, of a large number of people are involved, a petition under public interest under Article 32 would be a wholesome remedy as such, rather than going to the different high courts. Even there, we have felt many a time that the different high courts have looked into the whole aspect such a wholesome manner that the relief is provided. But yes, when the people across the country, Article 32 would be the right remedy to get your fundamental rights enforced in that particular context. And that's the beauty of the Constitution, that we are providing in this particular context remedies at different levels. And therefore, if changes are anticipated in the basic structure of the Constitution, it can cause damage. And therefore, it has been rightly interpreted by the Supreme Court that let the basic structure be not tinkered with. For instance, kidney is a basic organ of human body. One kidney cannot be replaced by any other kidney as such. The matching has to be done. The same is true regarding the basic structure of the Constitution. And that basic structure has to be handled carefully, effectively. Say that it is the savior of the Constitution, and I look around, particularly in the neighboring countries, it took more time to frame their constitution than the survival of that constitution. It didn't survive for those many years. Sir Ivor Jennings took 7 years to frame the Sri Lankan constitution. It did for that many years as such. And therefore, it is something which needs to be kept in mind, that how the basic structure has helped us in moving forward and still being governed by the Constitution. Another aspect which on this particular occasion I would like to share, the constitutional morality. Morality expression has been used in Articles 19, 25 and 26 of the Constitution. Morality in the general sense. I'm talking of the constitutional morality. The Constitution is silent about this particular expression, the constitutional morality. This expression was used for the first time in Keshavananda Bharati's case. They used the expression basic structure, which was not part of the Constitution. They used the expression constitutional morality, which was also not part of the Constitution as such. Now, like the basic structure, what is basic structure? It is not defined anywhere, What is constitutional morality is not defined anywhere. And it was being said it is an unruly horse. To control it would be a difficult exercise. My response to that is, and the experience teaches us, the constitutional experience, that this is not so. Constitutional morality has to be culled out from the different provisions of the Constitution as to how, take for instance, Article 14 of the Constitution speaks of equality before law and the equal protection of laws. Equals must be treated equally. That's the article speaks of. But through the years and the decades, Article 14 has been interpreted in a wholesome manner, in the sense the state cannot act in an arbitrary manner. Any action of the state which is arbitrary has been interpreted to mean discriminatory as such. The moment the state acts in an arbitrary manner, consequence of that is state is acting in a discriminatory manner, and it is hit by Article 14 of the Constitution. This is the constitutional morality which must be carried out effectively as such. I know constitutional morality doesn't mean absolute equality. It's not practically possible. Recently, a case where a person was arrested goes to the district court, from the district court goes to the High Court, from the High Court goes to the Supreme Court, and within a week he was out. Now, if this becomes the normal norm in our system, it would be ideal, but it's not practically possible. It's not achievable in that context. And therefore, what I'm urging is that constitutional morality requires that kind of treatment should not be in a discriminatory manner, in the sense that morality, constitutional morality requires that justice without delay should become a possibility. Yes, sometimes more time, sometimes less time, but the gap should not be that wide. We have to ensure within the constitutional parameters that this morality is actually effected as such. That's the real challenge. A system has to work out in that particular context. Similarly, take Article 21 of the Constitution. Article 21 has been so meaningfully interpreted. It provides for the right to life, the right to life, to live it with dignity. It provides even the right to die with dignity. It provides for a living will, for that matter. Now, this is what actually is the constitutional morality emanating from Article 21 of the Constitution. If this could percolate effectively, meaningfully, in different ways, in different aspects, it can go a long way. Article 20 guarantees the right to freedom of religion, faith, worship. The case constitutional bench dealt with Sabrimala Mala case as such, that was a big challenge. The constitution, by 4-1 majority, held the right that women, even within the age group of 10 to 50, who were not to worship in that temple, Ayappa temple for that matter, has been interpreted more meaningfully, wherein the constitutional morality of equality has been brought in. Yes, now that particular limitation is no more. What does that actually mean? Does it interfere with the freedom, with the faith that one actually practices as such? The answer is no. Why? The reason is, if I wish to visit and worship the temple, Sabrimala, there is no limitation I can go as such. And if I believe, I have faith that I should not be visiting, nobody can compel me to visit. Nobody can force me to visit. It is open to me to actually and factually go and visit. No one can compel me. And therefore, what I'm balancing in the context manner, in the context, those who wish to visit, yes, they have the freedom to do that. For them, freedom is that, yes, I don't believe in that limitation, that restriction as such. And those who wish not to visit, it certainly is open to them to visit, not to visit. Nobody can compel them. And therefore, this has been interpreted, to my mind, in a meaningful way. We have to look forward to that. Another aspect that I wish to touch upon this morning is relating to Article 142 of the Constitution, complete justice. Justice is the first promise of the Constitution in the preamble. Justice, social, economic, and political, all manifestations of justice as such. This justice means justice according to law. That is, we have situations in the domain of social, economic, and political as such. Apply the law to justice. The executive to act in accordance with law. The judiciary to ensure the rule of law to prevail. That wherever there is a violation of law, the judiciary would step in and give the relief. But then a question arises. Is justice according to law is the best kind of justice? Is there a gap and a space between justice and law as such? Many situations do arise in actual practice, which may not be strictly covered within the parameters of the law. Should every situation be regulated by holding ourselves as slaves to the law? No law, the jungle situation. Law of the jungle, for that matter. But there are situations when a law is enacted, say in the year 2020, you could envisage certain situations to be regulated through the medium of that law. 5 years hence, situation may change and it may be found that that law does not cover those situations, difficult situations. Yes, doing justice according to law is important, but at the same time, there is a gap, there is space between justice and law. Therefore, the framers of the Constitution were actually visionaries when they, in the original Constitution itself, provided under Article 142 that the Supreme Court, the apex court of the country, can pass any order, give any direction in any cause or matter before the Supreme Court to do complete justice. The framers thought that there is every possibility that within the parameters of the law, complete justice may not be practically possible. And therefore, they incorporated this special provision, giving the jurisdiction to the Supreme Court to pass any order to do complete justice. This is being looking forward to difficult situations, to hard situations, to situations which may not be covered within the parameters of a particular law as such. They could think of that. See, like the natural justice principles, they are so flexible to do justice naturally. You have to apply the principles of natural justice, which are not straitjacket principles as such. Similarly, in justice, and particularly for doing complete justice, you have to stretch and do justice in such a manner where otherwise it may not be practically feasible and possible to do complete justice dealing with specific situations. Harold Lasky once wrote a letter to Justice Holmes. How much I wish if the people could realize that judges are human beings. Justice Holmes wrote back, how much I wish if judges could realize that they are human beings. It is this realization which takes you to complete justice. Compassion, humanism, not to be slave to the black word of law as such, because the goal is to do complete justice. Complete justice would be possible when you blend all these elements of humanism as such. In fact, there is a fundamental duty for the judges in particular, I would say, though that duty is for the citizens in common. It is more applicable to the judicial fraternity. Compassion, humanism is a part of fundamental duty of every human being as such. More so in regard to the judges, the judicial fraternity. Judges every day deal with human problems of human beings. How can we divorce the entire judicial process from humanism and compassion for that matter? My basic message on this happy day, Constitution Day, is the challenge is gigantic. Let each organ of the state translate the Constitution into action, strengthen the Constitution. And if this role is played by each organ effectively, the question of reaching out of judicial activism would be balanced. Judicial activism is more active when the other organs that they do not do what they need to do. If they play their role actively to strengthen and translate the balancing would take place so far as judicial activism is concerned. Indian Constitution, the basic structure, and complete justice have been found to be the items which can be exported to other countries. Complete justice, Constitution, in the Bangladesh Constitution, in the Nepalese Constitution. I'm sure Indian Constitution has to contribute a lot in the Committee of Nations. This Constitution is the holy book. Let's take the pledge on this day to rededicate ourselves, that we act in accordance with the Constitution. Thank you so much.
So thank you so much for this, I think, very important address on a very important day. And I think, like I said in the starting, it is an important day for all of us. And what better could have been to listening to you and listening about the thoughts about each and every small minutes of Constitution of India. Thank you so much, sir. I don't think so. We need to get into the question answer section for this. This was just an address. So with your permission, sir, I will end this session and we'll move forward to other things. So, shall we? So I would like to thank everyone, Judicial Academy, for taking our time, and especially Dr. Balram sir for taking our time and giving this very important address on a very important day. And like any other webinars, this video will also be available on the Chandigarh Judicial website, so we can refer it and look at it again. I would like to thank my personal thanks to Balram sir for to ensuring that we are doing this on this day and doing it early in the morning, so that the work is not getting affected, but at the same time the words can be shared. So thank you so much, sir. And on behalf of everyone, I would like to now end this session. So thank you so much.